My lords, if I pick up on my point 6 of my final point of why I submit the judge was wrong to find that Betfair did not have and shouldn't have had knowledge. The first is that it is the evidence of the expert and Betfair's witnesses, which was contrary to that. So there's the evidence of Dr. Fraser, Betfair's psychiatrist expert, was that he thought Mr. Gibson clearly has a gambling disorder. That is the reference for that in our skeleton at paragraph 15. Dr. Needham Bennett thought he was a, quotes, self-evident case of gambling disorder. That is also in paragraph 15 of our skeleton. And Betfair's head of responsible gambling, Susan Lawson, considered it fairly easy to spot whether someone was chasing losses. So if I show you what she said, it's S6, tab 5, page 893, opus page 95. So from line 7, Mr. Mitchell is asking about chasing losses. If you read down, you see the answers as to how one spots that. Then over the page.
Yeah.
Lords, I submit that the legal inference you can draw just on paragraph 77 of the judgment is that Mr. Gibson was chasing losses. One sees his losses accumulate over time. That would necessarily mean essentially his putting money into the account, it running down to zero, putting more money into the account. And that is my submission of chasing your losses.
Mm-hmm. You know that? Do you know that that's what the account was doing?
Well, my lord, there's quite a lot of evidence at the underlying trial, I understand, to do with this, but at the moment all I can go from, for your purposes, my lord, is paragraph 77 of the judgment and invite you to accept my inference, which is that suggests that if one has this ratcheting up of losses over time and
I'm sorry to be tedious about it. A ratcheting up of losses over time is not the question that the witness was asked.
No, it's about chasing
it's
losses.
About running it down to zero and then more deposit and running it down to zero. It's not. I mean, I may be missing an obvious point, and I'm sorry if I am. It's not obvious to me that that is the same thing as what's in paragraph 77.
Well, my lord,
I think it is.
Well, my lord, I submit that it's not the case that he has put 1.4 million or 1.48 million into his account and then just gradually eroded that down. So there's going to be an element of what's in your account going down to zero and then having to replenish it and goes back down to zero and so on. And so in my submission, that does fall
but
within the.
If you have a I mean, I don't know anything about betting exchanges, but if you have a betting account with a bookmaker or an online account, you can put in however much you put in, and it'll run. If you go on making losses, it'll run down to zero. Then you have to put more money in it. And I think that's what she's talking about, isn't it? Where you keep topping up the account, and the evidence would be if you kept on topping up the account, if it kept on running down to zero, you kept on topping it up, then that would demonstrate you were making a lot of losses and you weren't actually making any money. Isn't that the point?
Well,
it's not this point, which is a different point.
Well, her point was about it being easy to spot chasing losses, and chasing losses is, in my submission, an indicator of problem gambling.
Was it put to her that the pattern of this account indicated that he was chasing losses?
She never looked at his account. She didn't. She wouldn't have looked at his account, so it wasn't put to her. My lords, so the judge's findings for ground one had two parts. One, the knowledge part, which I've addressed you on, and the second was that in any event, Betfair had appropriate policies and applied them. And that's at paragraph 134 of the judgment.
Yeah.
And I wanted to address you on that, my lord. So when the judge talks of appropriate policies, that is to some extent lifting wording he's used earlier in the judgment at paragraph 45. Did they have in place appropriate policies and procedures? Now, as to that, there is a risk that the use of the word appropriate there risks obscuring that Betfair needed to have appropriate policies in the sense that they would deliver effective customer interactions. And I submit that the policies that Betfair had in place were not compliant. They didn't deliver effective customer interactions in 4 respects. And I'll set those out and then I'll develop them. First is there was no consideration of the refusal of services, one of the LCCP requirements in their policies. The second is that the policy involved the designation of a problem gambler as limited to a person who had self-excluded, and later someone who registered with GamStop. I say that's deficient. The third is a system where the maximum customer intervention involves asking a problem gambler, potential problem gambler, if they have a problem, is a deficient system. And the fourth is if your system does not allow the responsible gambling assessor to see all relevant information in one place or be aware that it exists, that's a deficient system. It's not in accordance with the LCCP. So taking the first of those, refusal of service in my submission means saying no when you're asked. And I submit that a self-exclusion policy is not refusing. A self-exclusion policy is actioning an agreement you've entered into with a customer. Now, the requirement that licensees' policies include consideration of refusal and where it fitted in was, as we saw earlier, my lords, in the Gambling Commission's thinking right from the start and all the way through. And I submit it was absent in Betfair's policies. So if I take you first of all to a March 2014 policy, it's S1, page 8 of the Opus S1 tab 2, page 1. And if, my lords, you go forward, this is 2014, you go forward to page 9. Paragraph 4 deals with customer interactions. And so the following contains some examples of the kind of behaviour which will result in refusal of service or where customer interaction will be initiated. If we go over. So 4.1 declaration is made, that's not applicable here. 4.2, 4.4, 4.5, 4.6, 4.7. All of these are reliant on Betfair being told by the customer or by a third party on behalf of the customer that the gambler has a problem. The policies are all reactive to being told somebody has a problem. And if we go forward from that onwards to page 16, Opus tab 3, page 1. Let's say policy from 29th of April 2015. If one goes forward to page 18, there's a reference in the bottom half of the page to self-exclusion and customers having the option to self-exclude. The customer wishes to self-exclude in the second paragraph. And over the page further on, page 21, Opus page 6, there's a reference to VIP interaction. And they're saying there that VIP teams are to be included in any responsible gambling review. And the reason is because the VIP team has a closer existing relationship with the customer. And I'm going to submit that sort of thinking becomes relevant when one's looking at concepts of proximity and duties of care.
Sorry, did you say you were looking at the first one? When it was an external person raising the problem?
Sorry, my lord.
When did you say when you were looking at March 2014?
Yes.
That all of the 4.1, 4.2 and so on were external people telling you.
Well, it's either the
Isn't
customer.
one of them a member of staff? 4.3. So why is that not contrary?
Sorry, so 4.3 is about mental impairment or drug alcohol use. So I wasn't counting 4.3.
It's not limited to that. May not be in a position to make informed decisions about their gambling.
Yeah.
That's the criterion.
Well, my lord, sorry, I missed that one out. So yes, your lordship's right. 4.3 refers to whether a member of staff suspects customer may not be in a position. But the others, the others refer to the customer or a third party on their behalf. And if one goes forward in the document, we're into page 23. You see the same customer, it's essentially the same customer interaction policy that we looked at in the earlier document. And if one goes forward from that to page 30, that's tab 4, page 1, the same bundle, Opus. So page 31 sets out the objective.
Something else on the screen.
Okay, so this is Opus, it's S1, tab 4, page 2.
What is this now?
The 2016 policy.
It's a 2016 policy for Betfair. It's their
Hang on a moment. The judge quotes paragraph 53 and following from the 29th of April 15 draft responsible gambling policy.
Yes,
Is this what you're about to show us?
that was the previous document, my lord. The one
Because he quotes it, I think on the basis it was enforced from April 15, a paragraph at page, two paragraphs at 54 and 55, which you haven't shown us. Where are they?
my lord, the 29th of April.
The alerts. Many customers will use Betfair but not contact our help desk. Means in order to protect those customers, Betfair needs to have an effective monitoring program in place, allows us to proactively engage with customers and provide a point of consideration during their play. And that's exactly the point you were making, that it was all self-reporting, but it clearly wasn't all self-reporting.
My lord, so the 29th of April 2015 policy is the document in S1 at page 16.
Right, well,
That was
is that not the one you've just been showing us?
That was the one I showed you before I moved to the new document. Yes, it is.
Well, where is this section? Where are the two sections in that are quoted at 54 and 55?
So
There's one that talks about that interaction would take place when the customer self-identified as needing help, when the activity of the customer gave rise to concern during contact with the help desk, or where customer behaviour gives cause for investigation through Betfair's monitoring programme without prior notification by the customer.
Page 22, I think.
Certainly got the 55, page 22.
so the
22, is that right? top of that box.
Yeah, so it's all in there from 2015 onwards. So what's the complaint about that?
Well, my lord, there's no, I'm referring to these in support of the submission that I'll make in a moment. Policies don't contain any consideration of refusal of service.
Can I just answer the question that the two passages quoted in the judgment come from page 17 of the document you're looking at in the first place and page 22 in the second place?
Yeah. But I mean, what the passage of page 22 talks about specifically is team can take a number of actions, including but not limited to forcing a limit on the account, suspending the account.
But my lord, suspending...
That's a refusal of service, isn't it?
Well, suspending is a temporary measure.
Well, it may be a temporary measure, but I mean, it's implicit that if the customer doesn't ameliorate the position for whatever reason, then they won't get any, they won't be allowed to bet.
My lord, in the Gambling Commission's documents, where there's reference to refusing service, that is essentially...
So the complaint is that they didn't use the specific words refusal of service, is that?
Well, it's synonymous when it's used in the Gambling Commission's documents with terminating or ceasing the business relationship, with that sort of finality of refusal, not the suspension which is lower down the leaderboard of severity of action.
They can't say, we think you've got a gambling problem, we're not going to let you bet until you've spent 6 months pretending to gamble aware, and you can satisfy us that you've dealt with your problem.
So
They've got to say never again, have they?
well, my lord, once you cross the line where you work out that less intrusive interventions have not altered the customer's behaviour, then yes, my lord. So if, for example, one were to, if a betting exchange were to say your account is suspended for 6 months, you're supposed to go away, get some training, learn responsible gambling, they come back after 6 months and things are unchanged, then in my submission, it's not then appropriate for the betting exchange to apply the same interaction again. So well, let's do it.
What about if they said, well, we don't think you can afford it, you're spending more than you can afford, and then someone says, well, I just won the lottery, I can easily afford it now. They've still got to refuse service, have they?
Well, my lord, until there's a specific reference in the gambling documents the Gambling Commission documents to the big win scenario, your lottery example. That is bundle S3, tab 5, page 53. Page 5.
And you tell us what it says.
Yeah, it says those people are particularly vulnerable.
It says those people are particularly vulnerable.
Was it put to the Betfair witnesses that there was a flaw in their policy because although it allowed for a suspension of an account and didn't allow for an outright and final refusal?
Yes, it was repeatedly put to all of them.
It was, my lord.
I'd like to see the evidence about that.
So my lords, I was at S1 page 30.
Yeah.
S1 tab 4 page 1, and from there we were on page 31. Page 2. My lord, just to answer your question now about whether it was put to Betfair's witnesses that the absence of a refusal part of the policy made it effective. It was put to Miss Lawson. Sorry. No, my lord.
You have a reference.
Sorry, my lord.
Well, don't take time now, get Mr Mitchell to look. Okay.
So page 31 is the sets out the objective, defined process of escalation, review of cases, potential interest of both RG and AML teams. We go from there, page 32 over the page. And the top half of the page deals with the AML escalation process. And the bottom half looks at the RG review process. So that's if it's escalated to the RG team. And so in the top half, it sets out, during an enhanced due diligence review, the AML team will assess a customer's account for accepted RG behavioural traits during the, and I'm told that what follows is a number of triggers. And then under that, should a customer meet any of the above attributes, the case should be escalated to the RG team. And so, for example, if one looks at the fourth bullet up, the statement of what the source of wealth information found suggests the customer is spending beyond their means. So if for example, an AML review picks that up, it should be escalated to the RG team. And then if we look at the RG team, when an escalation is received by the RG team, they'll do one of a number of things. And if one looks through them, they come down to sending an email, contacting over the, conducting an RGI, which is a responsible gambling interaction over the phone. So it's email or telephone RGI. Those are the outcomes of the escalation to the RG team.
This is a process document. This is different from the one. This is the same date, isn't it? This overlaps with the other things we looked at. So why, the fact that it may not say what the outcomes will be, is that relevant to anything?
Well,
This meant, what I'm trying to understand is whether, no doubt, the word exclusion or refusal isn't in this one, but that's because it's describing the process, not describing the interaction or the outcome.
so my submission is, my lord, it is a different document, of course, and it is setting out a process. My submission will be, when you read this with the other policy documents we have, you don't see any point at which Betfair itself will say, I'm refusing service. So what, apart from the point that was made by the Chancellor, which is if suspension qualifies as refusal of service.
Is suspension here either?
No, it's not mentioned here either. And if we go from there to page 35 of the same bundle, that's Opus tab 5, page 1. This is the first merged policy after the coming together of Paddy Power and Betfair. Page 36 sets out key messages. And the
fourth message, it doesn't use the word refusal, but it's pretty close. Prevented from playing Paddy Power Betfair. Anybody with a problem?
Yeah, it's any customer that identifies themselves as having a problem is prevented from playing with Paddy Power Betfair. So this relies on the customer themselves to identify that they have a problem. There's no reference there, my lord, I submit, to Betfair independently taking that view without the customer volunteering it. And page 37. Page 37 refers to, in extreme circumstances, excluding the customer from betting with our products or services either prematurely or for sufficiently long enough that they're able to assess their gambling behaviour. So that, from Betfair's side, I would say, well, that's quite promising, but it doesn't follow through into the actual policy. they say that there. But if one goes over the page to page 38, where the application part of the document begins, the processes part of the document begins. So key principles, so under application, second paragraph refers to key principles, first of which is protection. And again, it's a reference to preventing those customers who have identified themselves as having a problem from playing. That I submit is different to refusing service to somebody who still wants to play. And if one goes then forward to page 40, there's a heading of responsible gambling control tools. And those tools all require the customer to want to set limits on their gambling or to want to self-exclude temporarily or permanently. My lords, from there if one goes to the next policy, which is at page 45, this is April 2018, Opus, it's tab 6, S1 tab 6, page 1. And if one goes to page 46, one sees a similar key messages document. That page, sorry. The second box on that page, this is Opus page 2 now. The second box refers to RGIs, Responsible Gambling Interactions. And those are by the VIP team we see later on in the document. So if one jumps forward to page 50.
What about the fourth box on page 46?
Yes.
Account suspension,
Yes.
where a customer indicates
Yes.
they are ... potentially spending beyond their means during review.
So
Is that naughty?
so that
Leave aside your point about the difference between suspension and exclusion. Is that not exclusion or suspension when the information from the customer indicates that they're spending beyond their means, or potentially spending beyond their means?
well, it's where a customer indicates they're experiencing issues or potentially spending beyond their means. So this again in my submission, my lord, is reliant on the customer volunteering that they're having problems.
Is it? If you're having a review and the information you get from the customer indicates that they're potentially spending beyond their means, that's the trigger, isn't it? It's not they accept that they are.
Well,
It would be an odd way of applying the policy to say what that means is we're only going to do it if they admit they're spending beyond their means. That would be a very odd reading, wouldn't it? They asked.
my lord, that is, I submit, what they do there. It is asking the customer, are you comfortable with your gambling? And if the answer to that is yes, as I'll show you in a moment, the usual response is then, well, okay, carry on. And so it does, by submission, require the customer to volunteer that they are having a problem.
And does it follow that the suspension in 2018 was not in accordance with any of the policies on your case? They were acting outside their policies.
So the 2018 suspension, the original was originally based on an AML concern, that documents had not been sufficiently provided to justify the AML concern. So that was why that suspension took place. This appears to be more sort of an RG level, the affordability and whether you're responsibly gambling. That appears to require, my submission, the customer to essentially put their hand up and say they would like to self-exclude or they consider themselves to have a problem. If one looks at paragraph 48, sorry, page 48, the RGI process, much of this is redacted. Spike report process halfway down the page.
What was the reason for the redaction?
It's the specific triggers that lead to an AML or RG concern, so that Betfair's customers don't know exactly when that will.
They're the specific triggers that lead to an AML or RG concern. The idea is not is ensuring Betfair's customers don't know when that's going to happen. That the idea. I understand that was the idea.
Well, this is why it's all rather awkward and difficult, because there's a box. There's a whole load of stuff about leaving aside my Lord Justice Bird's point that this is really about processes. There's a whole box on page 52 about AML escalation process, which is blanked out. How do we know that that didn't include something that would say the whole point about AML escalation, as I sort of understand it, is it's not dependent on the customer as it were, self-reporting.
There's an unredacted version of this document in the confidential bundle that you have. I can give the opus reference, which is SB8/21/1.
Maybe I'm barking up the wrong tree, but quite likely.
You've got a bundle page number.
I'm very sorry, I don't, my lord. I just have the opus reference. I understand there's a concern because it's now appearing on the screens, and the court is sitting in public.
Take it off the screen. Can somebody give us the references in the bundle so we can look at them as they were privately? I can't find anything that corresponds with that document. Can you go further? I think it's something else. Sorry, looking in the wrong.
My lord, we will provide references for any of these redacted policies and where one can find them in the hard copy bundles, in the confidential hard copy bundle. I deliberately tried to keep it in the non-confidential bundles so that we wouldn't have to have interruptions, but I understand your lordship's point that it's unhelpful looking at these when they're redacted.
Judging by the index of the confidential papers, it doesn't have in it the document we were looking at, the 2018 document. I'm only going on leaving the index.
This is the one that purports to be at tab 6. No, I see. No, sorry, that's this one.
It doesn't seem to be in the bundle.
Yes.
So my lord, the point I was going to make from the, which is one I can make from the redacted version at page 48, is that in terms of the spike report process, the most serious form of interaction is an RGI phone call. It starts out with an awareness email, a phone call, and those are in CAAP stage 3+ and reviewed for an RGI phone call. And I submit the fact that there was no effective policy for refusal of
That
service.
just mean as long as you have a phone call, that's all right. It will depend on what the outcome of the phone call is.
Um,
And again, we'll have to look at this sensibly and in the light of the fact that the judge found that Miss Lawson took her responsibilities very seriously.
Miss Lawson didn't know anything about it.
So, my lord, if I take you to Miss Lawson's evidence just on this point.
Right.
So it's at S6, page 833. Opus, that's S6, tab 5, page 35. And so there's a period of evidence in which Ms. Lawson explains Betfair's CAAP programme, and line 21 says you would have had this interaction, being the RGI interaction, and if the person confirmed that everything's okay, you wouldn't have closed their account, would you? She says no, and that would certainly be the case before the introduction of the cap in the early years too.
Move on to the next page, please.
Yeah, yes, over to the other page then. So,
This was in the call script. The script of the call. The script of the RGI call explains that they don't do anything else.
my lords, there's a script for an RGI call, and that is at S8, SB8, tab 12, page 21.
Page.
Page 21. That's the opus. That's the opus reference.
This is the evidence of Mr. Ackcliffe.
So, my lords, that's my first point, that the policy made no provision for effective refusal of service.
Mm-hmm.
My second point is policy involved the designation of a problem gambler as limited to a person itself excluded. That is alluded to in the judgment, paragraph 54, and I'm not sure if it's in dispute. I don't think it is, but one can see it in Betfair's assurance statement to the Gambling Commission in 2018, and that is in S8, page 1946. That's S8, tab 17, page 1, and if one goes forward in that to page 1969, opus page 24.
This is in the confidential bundle.
This is the confidential bundle.
Right, here we go on the screen.
Ah. So in the first column, so top of the page should say part 1B, and then there's a box,
Sorry, what's the page number again in the hard copy?
1969. And so on page 1969 is a table. The first column is headed, what is the current prevalence of at-risk stroke problem gamblers within your customer base? And how do you identify it? How has it changed since your last AS assurance statement? And if one sees the answer, pick it up at the very bottom of the page. PPB previously defined a problem gambler as customers who choose a lifetime self-exclusion after receiving a responsible gambling interaction. Post-introduction of GamStop, our definition of a problem gambler is as follows: the number of accounts which excluded with PPB during the month and then went on to exclude via GamStop. So their definition is self-exclusion. And the second column is headed, what actions are you taking to address at-risk stroke problem gamblers since your last assurance statement? And if one goes to the answer, again picking up at the bottom of the page, customers who meet our definition of problem gamblers are no longer able to transact with the company. And so that's those who have self-excluded. And just then going over to page 1971, and if one looks at the right-hand column, provide an estimate of the percentage of revenue derived from your at-risk stroke problem gambling customer base. And the answer is, for the at-risk, they calculate 7.2% of total revenues. And then at the bottom it says, revenues from problem gamblers is 0%. Per our definition of a problem gambler, these customers are closed as soon as they're known to us. So essentially the definition means you never have a problem gambler. And my submission is that a system that defines a problem gambler as limited to someone who's self-excluded just captures a small subset of problem gamblers. It's the equivalent of assuming drug addict or an alcohol addict who hasn't self-excluded by checking into rehab doesn't have an addiction, even though they may be taking personal risks to feed that addiction. And it leads to the, in my submission, slightly unreal consequence that Betfair can say none of its active playing customers are problem gamblers, because by definition, problem gamblers will have self-excluded already. My third point as to why their systems are inadequate is the RGI message. A system where the maximum customer intervention involves asking a problem gambler the questions that you saw on the screen earlier is a deficient system, I submit plainly so. And that is particularly in circumstances where it's recognised that problem gamblers may not be straightforward and may try to cover up, as was alluded to by the judge in paragraph 125 of the judgment. And so I submit that if, as found, Mr. Gibson was a problem gambler from 2015, a system reliant on asking a problem gambler whether he has a problem is an obviously deficient system. Now, my lords, I'm not sure if this is going to work. The plan was to have your lordships listen to a 20-second call, which was actually an RGI call, responsible gambling interaction call. Apparently, everything's been teed up with a court, and it should be possible. If it looks like it's not, then we will. It is. Okay.
Do we need to know anything about this particular customer?
This was Mr. Gibson. So this was Mr. Gibson. This was a call to Mr. Gibson after his account had been closed, suspended, and he was calling to, when an account is suspended, there is a message to contact Betfair, and then one has this call. This is the RGI call.
Betfair speaking, how may I help? Good evening, Betfair speaking, how may I help? COR3Y2309. Second. Okay, and can I confirm your date of birth and your postcode, please?
78, LS739HB.
Okay, how may I help you today, sir?
Yeah, I'm trying to put a bet on. I've got money in the account saying I can't put the bet on.
So what I'm seeing here is that this account has been suspended from our responsible gambling team in order to confirm a couple of issues. Are you able to are you happy to continue basically?
Yes,
we have
yes, of course.
Perfect. So just one moment, let me just find. So, basically, I have two questions to ask if you're happy. So first one, do you feel comfortable with your current level of spend and activity?
Yes,
Perfect. And are you aware of the player protection tools available? For example,
yes,
such as
of course, yes,
self-exclusion?
yes, of course, I read that all the time, it's fine.
All right, so one moment, sir.
It was suspended until they could speak to him. That was the last point until they spoke to him. Only until they spoke to him.
Perfect. I've just deactivated the account for you now, sir.
Okay, thank you, bye-bye.
Thanks for your understanding.
Bye.
So, my lords, this is a call that takes place after his account's been suspended for RG reasons. This is the most serious form of customer interaction. And I submit it is deficient. That a policy that involves calling up, speaking to a customer whose account has been suspended for concerns about problem gambling, affordability, to ask them those questions in what seems really rather tick box fashion is symptomatic of a deficient system.
What was the date of that?
Just a moment, my lord.
It's the 14th of December 2018, so he's already lost hundreds and hundreds of thousands.
It's 14th of December 2018.
2018.
Yes.
Was that call played to Miss Lawson when she asked questions about it?
It was put to Mr. O'Keefe, the script.
She was heavily responsible for gambling at the time.
Mr. O'Keefe wrote the script, so it may have been him.
So my other junior says he thinks it was put to Mr. O'Keefe. The script of the call was put to Mr. O'Keefe, who wrote the RGI questions.
Well, what I really want to know is you've just made a submission that call demonstrates that the policy was deficient. And I just wanted to know whether the call was played to any of the witnesses from Betfair. And it was then put to them that demonstrated that their policy was deficient. So they have an opportunity to deal with it.
Yes, it was. In terms of which witness is, I will. Julia, feed me the line in a moment. My lords,
This I mean, just trying to fit this in with the judgment. This is in the period covered by paragraph 105. Right. What was it that triggered the alert in this particular case?
my lord, all I can go from is what was in the
Sorry, what was the date of that call again?
14th of December 2018.
So when they have the RGI calculated, because it's got high enough to need an RGI, they have to wait till they can contact
I mean, whether that was an inadequate response rather depends on what it was that had triggered the alert, doesn't it?
And the fact is, it was only a month and a half before there was a further escalation.
So, my lord, my purpose for having you listen to that was not to ascribe any particular importance to that date or that call. That is how an RGI call would play out. So,
Well, that was how that RGI got played. And if we go back to the period when he was suspended and it was all being carefully dealt with by
Ms. Klein's,
well, and
Ms. Gibson, Ms. Lawson.
and all of those really who deal with the period of the suspension in the early summer of 2018. Doesn't follow that that's what the nature of an RGI call would have been on that occasion, does it? That it looks as though, and again, we're island-hopping a bit, but it looks as though at paragraph 99 of the judgment, it was only a review of all the information by Matthew Brown on the 16th of July that led to the suspension being lifted. That's not dealing with it with the kind of RGI call that we've now been looking at. So it rather depends what it was in December.
Yeah.
That gave rise to the trigger.
And also you've got the second sentence of 105. Most of the 8 alerts led to some form of interactions, but some were so close to previous interactions that no action was taken. So we just don't know unless we have the full picture of every RGI call and what was said. We wouldn't have a basis for saying just on that RGI call the policy was deficient. As I said, it's classic island hopping. Right, anyway.
so my lords, if you're interested, SB2 tab 12 has a log of all of the RGI calls that took place.
SB2 tab.
That is, my lord, page 89. Yes.
89.
And essentially, the point I would make is that they're all effectively of that flavour.
These aren't RGI ones at all. RGI is here, but this is everything.
First RGI record is row 117, page 27.
Right, so your lordship's right, they are all the calls made. The first RGI one is at entry row 118, page 27. 117, sorry. And then 138. And then
I heard of
141.
numbered rows.
Those are rows. You don't
Page 27.
Favorite page?
The 5th of October 2018.
until Mr. O'Keefe's witness statement deals with all of the interactions. My
So was
lords,
that, did you say that was the 17th of December?
14th of December.
14th of December, thank you.
So the
Did
one we've
seem
got on
to
the
have-
screen,
We don't seem to have a 14th
can we,
December.
can we go on to the next page, please? And again, thank you. That's all right. I just want to get somewhere around the 16th of July. So you really need to go on, I'm afraid. And again, sorry.
It's page 38, it's the 16th of July.
Page 38 of the 16th.
Some of these are the calls that the judge sets out in his judgment. And this isn't just RGI calls. This is a whole series of emails and communications, some of which are internal.
I don't want to spend too long on this. I've just been looking at the hard copy document we got in the bundles rather than this seems to be the native version that's being put up. But so far as I can see, around the period of the 14th of December, there's a number of them just before that have SOW follow-up and refer to meeting football games and so on. So, which will tally with what the judge says at 105, so close to previous interactions that no action was taken. I have to say, I'm finding it very difficult to read in hard copy.
Yes, quite, isn't it?
But
I'm surprised by that.
it looks a bit like that. But it's, speaking for myself, I'm not sure I find it terribly helpful just to take one example at a particular point without knowing all the circumstances that surrounded it.
And my lord, earlier, Justice Popplewell, you asked me a question of what prompted the 14th of December 2018 call. It's in Mr. O'Keefe's witness statement.
Which is
So the unredacted version is in SB 8
in the confidential one.
confidential bundle.
Yeah.
Tab 12, and it's page 13 of the witness statement.
Page
13 of the witness statement, my lord.
A bundle page.
I only have the opus on it. It's of the internal witness statement numbering, my lord, would be page 13.
Where do we find the witness statement starting?
Whose witness statement?
This is Mr. O'Keefe, the person who wrote those RGI questions.
His first statement or his second?
It's his first statement.
It's his first statement.
Internal page starts at 1685.
Internal page 13.
So yeah, the internal page number starts at 1685. So page 13 will be
1697.
1697. And it's little p at the bottom of that page.
1697, did you
Yes,
say?
This sets out all.
And this is the statement that sets out all of the interactions.
So he deposited 23,000 the day before. And so he suspended till they spoke to him.
So it was the fact that he deposited 23,000, was it? That
Yes, yeah, the deposit spike. And the earlier part of that statement, my lord, the earlier part of that paragraph 34 sets out all the earlier triggers that he hit.
This just sets out what the triggers, doesn't it? It doesn't quote what was said.
No, it doesn't quote what he said, by the way. It doesn't recite the conversation.
It was in a mailing, that's a standard mailing.
And my lord, just to finish this third point, if one looks at the hard copy bundle, may be quite hard to read. It's at S4 tab 8, page 321. And Opus, maybe we'll bring it up, it's S4 tab 8.1, page 2. So this is a document that's described by Mr. O'Keefe as a summary of the records available at Flutter of reports triggered and reviews carried out on Mr. Gibson's account. I'm not finding Opus any easier to read than my.
I'm not sure that helps.
Okay.
In any case, the point I was looking to derive from this document is that it suggests that in a limited 5-month period from September 2018 to February 2019, Mr. Gibson was repeatedly flagged as somebody for whom an RGI was required. So he's hitting triggers. And then Betfair would go through an RGI where it would ask him if he had a problem, he'd say no and they're allowed to carry on. And I submit that is a deficient system for dealing with somebody who's constantly hitting your problem gambling triggers. My fourth and final point as to why the policies of Betfair are deficient is if your system doesn't allow the assessor, the RG assessor, to see all relevant information in one place or be aware that it exists, it's a deficient system. Now, in the judgment, paragraph 80 said it was impossible to separate AML requests from RG interactions. We've touched on that a little already, aimed at slightly different things, but there is an overlap. But that finding supports the proposition that all of that information, whether it had an AML hat or an RG hat, should have sat and been accessible in the same place, whichever side you were looking at it from. And now, in the judgment at paragraph 109, I submit the judge here conflates two things. So his lordship says the fact Mr. Gibson consistently satisfied AML checks makes it impossible for Mr. Gibson to argue that the size of his losses was of itself enough to raise reasonable concerns. I submit that conflates AML and RG. One can pass AML checks because selling your assets to fund your gambling habit. It doesn't necessarily follow that means you can afford your gambling habit. So to say you passed your AML checks, therefore it's impossible to contend there's any RG concern, is conflating the two. And it's a view that ignored the expert agreement. I won't take you to it, I'm conscious of time, but for your reference, it's S8, tab 16, page 1894. And paragraph, the experts agreed that AML policies were not designed to address RG issues. Earlier, the court looked at your lordships raised with me a message that's referred to in the judgment, a 4th of July message, which which your lordship raised earlier, and it set out AML concerns and what have you. It's the important point is that was never shared with the RG team, so that stays AML part of the database. If one wants to look at that message, it's at S2, tab 8, page 85. And referring to the sale of properties and the loan, and this impacting affordability. And at the top of the page, Mr. Rourke, who is his VIP manager, doesn't then say, I'm referring this to the RG team. He goes back to Mr. Gibson for more information. And this email wouldn't have made it to the RG team. And another message also referenced in the judgment.
Well, rightly or wrongly, that's because he was asked in the last paragraph of Mr. Brown's email if the customer could provide further details, and he says, I've gone back to him to ask for the further details.
Yes, my lord. The VIP team who should be involved in the RG part of the analysis, I would submit, receiving information that suggests something's not entirely clear about affordability, should be referring that, or at least make this information available to the specialist RG team. What view they take of it is what view they take of it, but that it should at least form part of that common information repository. And on a similar point, a message at S2 tab 9 page 86, next one along. This is referred to in the judgment of paragraph 98. This is an AML note to self. It was never not communicated to the RG team, and that's mentioned in the judgment.
Where does it say that?
Paragraph 98, my lord.
Sent further information. Sent an internal email on the
Yes.
6th of July. Doesn't say who it was sent to. The end of, just before the quote.
Yes, no, it says internal. You're right, my lord. It doesn't. I'm given to understand it was not sent to the RG team. It was essentially a note to self.
Well, and what he said, and again, at the end of that, he says, and he goes through, we went through some of this earlier, the evidence about the profitability of Mr. Gibson's company. And he then says he'd like some evidence that the tenants are actually paying the rent into the bank account. And once that's received, he'd be content for the account to be reopened.
So why do you call this a note to self? I'm sorry if I'm missing something.
To their platform, their AML system, records it on their AML system so that he can go back to his reasoning about why he's satisfied.
So, my lord, it's recorded on an AML system at Betfair, so the person who made the note can go back to review their reasoning at a particular point in time. But the point I wish to make is this is information that the AML team have. It is information that is, in my submission, relevant to assessing responsible gambling, affordability, the sorts of things that fall within the control of responsible gambling analysis. But if it's not being shared with the responsible gambling team, then you are not then making decisions based on all the relevant information. And so I submit those are the four respects in which I submit Betfair's policies were not effective or appropriate in the sense of being effective. And just as a sense check to that proposition, my lords, I'm not going to take you to the underlying documents, but I will just mention them. We do pray and aid the view of Mr. Justice Griffiths in Deer and Flutter Entertainment. I appreciate it's a different case, but having looked at similar policies in the context of Paddy Power, he took the view that he took an adverse view of the approach of the company towards those policies. And we referenced that in our skeleton. And the paragraphs on which we rely are paragraphs 108 to paragraph 110 of the judgment. The judgment is at A3, tab 36, page 1249. And a further sense check we submit is Betfair's public statement in respect of the Gambling Commission's agreement in 2018. If I just briefly show you that, that's at S7, tab 5, page 1438. And it relates to accepting that it breached paragraph 3.4.11 in respect of 5 particular customers. And page 1439, under response by licensee, it says PPB acknowledged that certain policies enforced the relevant ineffective. It had already evolved those policies, and that process remains ongoing. No, I don't want to get too distracted on this point. My own friends say you can't rely on that. The rule in Hollington and Hewthorne. Judges making decisions today shouldn't have their minds swayed by what someone else has decided, be it a judge or a regulatory investigation. And I acknowledge that submission works to a point. I submit, though, that Betfair's response, Betfair's public statement, isn't part of any decision maker's determination. So in AXA and Santander, we'll deal with it very briefly, my lords. It's AXA and Santander, which is A3, bundle A3, tab 37, page 1298. Mr. Justice Field took the view that a final report produced by the executive branch of the FSA would amount to a decision maker's determination and fall within the rule. But I submit that Betfair's public statement is not a decision maker's determination. So I only rely on it as a sense check to my proposition that Betfair had deficient social responsibility policies in the period 2015 to 2019. And that
Just on the public statement, that I mean, you're absolutely right, there was a breach of 3.4.1, but that was in the context of criminal activity, wasn't it? It wasn't in the context of protecting the customers from their own.
So my lord, it had AML aspects.
Folly. There were people who were criminals who were using it for money laundering.
Well, it had AML aspects to it, so there were aspects of criminal money being used, but there was also a RG aspect to it as well, if one looks at it. So, my lords, that ends my submission, my proposition on why I submit the judge was wrong to conclude that Betfair was not in breach of the LCCP, both on the knowledge and on the appropriateness of Betfair's policies. I then move, my lords, I'm conscious of time, I move to ground 2, duty of care. In terms of the approach to the analysis, I don't think there's anything between my learned friend and me. The generally accepted view now after Robinson, West Yorkshire and N and Poole is the court should try to take an incremental approach to questions about duty of care, take the closest analogy as a reference point and work from there, unless you're in a world where the point's never really been considered before, in which case one approaches it on first principles, looking for whether a duty would be fair, just and reasonable. So, my lords, I'm not going to take you to the 3 authorities, just because I'm conscious I should move it on, but the authorities I was going to take you to were, briefly, Customs and Excise and Barclays Bank.
Yeah, we're familiar with those cases.
Quite. And Robinson and West Yorkshire, and then N and Poole, which essentially says adopt an incremental approach to novel situations, and whether one works out whether it be appropriate to make that incremental jump is assessed by applying a fair, just and reasonable criteria. So the closest reference point in our case is obviously the Calvert decision. My learned friends agree, but they say the analysis starts and ends with Calvert, which was very much the view the judge took. I disagree respectfully for three reasons. I say first, even though Calvert may only be 17 years old, it relates to gambling in a different age, which means much of the reasoning that sits awkwardly in a digital world. Second, the Gambling Act 2005 was not in force at the time of the events with which Calvert was concerned. And third, Calvert didn't consider the duty being argued for in this case. In that case, there was a broader duty put forward as to betting operators owing a duty of care to all problem gamblers. We're not arguing for that. And there was a narrower duty in relation to giving effect to a self-exclusion agreement. That doesn't arise here.
Yeah.
So taking each of those very briefly, Calvert considered the question of a duty of care in the context of telephone betting, with occasional betting in William Hill's betting shops. Enticements to customers were by way of mail shots, promotions and betting statements sent by post to their address. You get that from paragraph 19 of the decision. Now that's not the same world in which the present case arises. What's changed since then is, of course, the proliferation of online gambling through smartphones. And that the use of technology also means, my lords, that betting companies now operate highly sophisticated software which records all of your user data, analyzes it, nowadays using AI, more and more sophisticated fashion, works out how much you bet, when you bet, what you bet on, etc. Now, in terms of the technological gulf from the times of Calvert and today, I'd like to show you very quickly an article and an authority. The article is by Professor O'Sullivan. It's in tab A, it's in bundle A3.
A2.
A3, A3, second part, tab 41. In my learned friend skeleton, Professor O'Sullivan seems to have morphed into Jane Stapleton, Professor Jane Stapleton, both eminent law professors at Cambridge, but they are different. It's Professor O'Sullivan on whom I'm relying for present purposes. So, what has the abstract there? So, if one goes forward to page 1458, I'm going to try to fast forward. I would invite you, my lords, just to read this article. It sets out what I submit is quite a compelling case for why she argues in this article for a reassessment of the broader duty of care. I am not arguing for that. I am not going that far. It's a much more limited duty I am arguing for. But I do submit that much of her analysis is helpful, or at least relevant to what your lordships would have to decide. What she does.
So I don't want to slow you down because I know you're short of time, but the difference between the broader duty and the narrower duty. Broader duty is one owed to all problem gamblers. Narrower duty owed to those who are actively managed. Is that?
Yes. So the narrow duty in Calvert was the failure to implement the self-exclusion agreement. So that's what the narrow duty was in that case.
Yes, but what is the narrow duty you're contending for?
Yes, not just to all problem gamblers you actively manage. If one goes to page 1462, she sets out the facts of Calvert and what have you. 1462, she posits the argument that Calvert is out of date both legally and technologically. 1462 to 1463 is why she says it's legally out of date. One of those is the Gambling Act 2005, which I also rely on.
Yeah.
If we go forward to page 1464, she addresses why the case is technologically out of date. And it's, I'm not going to go through all of this with you now, my lords, but it's essentially making the point that we now live in a world where that there is a lot more in the way of data retention and analytics that makes much of the analysis in Calvert outdated. And if one goes forward to 1470, 1469, she starts the broad duty of care revisited section. At 1470, a part I'll just pull out of that page is she makes the point that one of the reasons given by Mr. Briggs, as he then was in Calvert, for rejecting the broad duty was the difficulty that a bookmaker could in the ordinary course of business identify a problem gambler by way of what would amount to analysis of data or medical diagnosis. And her riposte, which I adopt, is that might have been justifiable in respect of a receptionist in William Hill's call centre, but it's not justifiable in the context of modern-day gambling software. And as time goes on and AI becomes even more sophisticated, it will be even less justifiable as an argument. So my first point is the technology has moved on. There's an authority that also illustrates that. If I could invite you to turn up also in A3, tab 40. And it's the decision of Mrs. Justice Collins, RTM and Bonterre. And so if one, paragraphs 1 to 5 set out the brief background of the case, it's a different, the issues are quite different to our present case, but I'm only showing you this for one point, which is if one goes forward to 1419, paragraphs 79 to 86 set out what Sky betting and gaming does by way of capturing of data and data analytics, and how that's used, how that's analysed and used for direct marketing. And at paragraph 88 on page 1421, SPG considers itself a market leader in safer gambling, and there's a reference then to using data modelling to operate a control framework. I just invite you to read that. Now, my lords, although SBG is a different gambling operator to Paddy Power Betfair, I submit it's a reasonable assumption that market-leading betting companies will have broadly comparably sophisticated methods of capturing and using customer data. And on that, if I take you to a document we looked at earlier, but a different part of it, bundle S3, tab 2. That's page 104. February 2015 Gambling Commission document. If one goes to page 106, and the paragraph at the bottom of the page, it makes the point that the same data analytics that's used to induce and entice customers can be used to protect those that are at risk of harm. And I submit that's also relevant to the imposition of a duty.
106.
I do, yes, it's S3, page 106. And on a sort of allied point, if one goes forward in the document to page 112, under customer interaction, paragraph 5.3, there's a reference to data analytics being used to generate being overlooked when it comes to customer protection. And 5.4 refers to operators being best placed to consider how all relevant sources of information on individuals for commercial reasons might be used for social responsibility purposes.
Yeah.
So a lot of very detailed information, and it's that very information that can be used both to generate profit and to protect them. I submit that becomes relevant when one's thinking about imposing a duty. My Lords, I was going to take you to a series of emails as to the kinds of information that Betfair had about Mr. Gibson, and I'm conscious that if I do that, we're going to be really running down the clock. So I'm going to move on. And
Are they in the judgment, those emails?
no, they're not. Perhaps one way forward, maybe if I just give you the references of the emails, and what they do. So the points I was going to in the emails to show that Betfair had very detailed information about exactly how Mr. Gibson bet. So, for example, when he moved from betting on tennis to betting on football, the inducements changed. They were moved over. When his betting dropped for a while, there was an active push to try to entice him back to bet again. And so it's very much just the idea of the sophistication of the data analytics that now exists enables the betting provider to be able to, I don't want to use the word weaponize, but exploit that data in a way that a more efficient way than perhaps would have been possible 17 years ago.
Yeah, well, I think, I'm not sure we need to see the emails for that. That speaks for itself in the world in which we live.
Yes.
It's rather like any internet search, isn't it? What you get will often depend on. So if you've looked at something similar in the past, what you'll get is whatever the most number of hits on that is. And it can be quite frustrating on occasions if you're looking for something specific. You can't find it because you're getting a whole load of other stuff.
It's an extension of that, my Lord.
It's just the same sort of idea,
gambling
isn't it?
context. So, His Lordship borrowed heavily from Calvert, and in truth, in my submission, he largely cut and pasted the Calvert logic into
And
present
you just
case.
say, well, that's out of date.
I do. But an important component of that reasoning was he characterised as doubly exceptional a duty to protect a person from financial harm they might cause to themselves. And that's lifted from Mr. Justice Briggs' remark in Calvert, which itself is lifted from Lord Hoffman in Reeves. Now, I'd make two observations on this idea of it being overly paternalistic or exceptional to place a duty on a betting operator to take reasonable care to protect a person from financial harm they might cause themselves. First, that judicial reluctance to avoid protecting vulnerable persons from themselves is out of kilter with one of the key objectives of the Gambling Act. So Parliament's legislated to protect certain vulnerable persons from themselves in the Gambling Act. And it's done so by requiring betting exchanges to adopt and put into effect responsible gaming policies that deliver effective interactions for vulnerable persons. That's Parliament's intent. If betting exchanges don't live up to what Parliament intends of them, I submit there is or should be nothing exceptional or doubly exceptional in the common law giving effect to that legislative intent. Subject, of course, to a debate as to whether the codes of practice could in principle confer a civil remedy, and I made my submission that they can. And second, my lords, just that formulation, a duty to protect a person from financial harm they cause themselves, it relates to a different situation and a different era. The proposition perhaps has greater resonance if you think of a person walking into a betting shop, about to cause harm to themselves by placing a bet, in circumstances where the betting shop has done little or nothing to induce them to come into the shop and gamble. Now that more passive or restrained provision of gambling services is to be contrasted with the more active provision of gambling services in the present case and in the modern world. So, protecting someone from harm they cause themselves should be viewed through the lens of the extent to which the person providing the services has induced or exacerbated that financial harm. So, it's equivalent to the betting shop going round to the punter's house every day a few times to try to coax them into gambling. Does that change the analysis? And I submit it does. Apart from the point being, so my lords, I submit that Calvert is not the impenetrable obstacle that the judge thought it was, or that my learned friends contend it is. And so I submit that on an assessment of all the circumstances of the case, the judge was wrong to hold that there was no duty of care owed to Mr. Gibson. That's my third proposition. He agreed that foreseeability existed on the three-stage test, if you can call it that, but he disagreed that proximity was made out or that it was fair, just and reasonable. Now, I submit that he was wrong to do that. So on proximity, as your lordships identified, a key part of the duty we're alleging, it's not duties of all problem gamblers, it's just those whom you actively manage. Because that involves extensive use of their data and analytics, having someone who interfaces with them, and so on. Now, the judge discounted the involvement of the VIP manager. He found the VIP team was about fostering customer loyalty. And I submit that that just means customer loyalty is ensuring the customer spends their money with Betfair and not a competitor. So implicit within that is the idea that the VIP manager is looking to sustain or increase the spending that currently takes place. And so that in my submission is a relevant factor. We see from the policy documents previously that VIP managers were brought in to deal with RG interventions because there was a perception they had a closer relationship with the customer. So in my submission, all of that is relevant when you're looking at the duty. And on whether it be fair, just and reasonable to impose a duty, the point I would draw to your attention is it's relevant to note the very data that betting exchanges store for profit reasons can be used to protect. So it's an eminently achievable duty. Betfair ascribes a true value to customers, which is the value of the customer to Betfair. And the more valuable they are, the more active management they get. And VIP customers are managed more actively. This is in Mr. Rourke's cross-examination, just for your notes. S6, tab 3, page 720 to 722. But
by actively managed, you mean encouraged to bet to a greater degree
yes.
than is true of the general clientele through the normal marketing.
Correct. You are part of the VIP team, so
it's a question of degree rather than a difference of nature.
Yes.
It's just more active marketing than the marketing that targets people generally.
Yes. And that includes another reference, Mr. Rourke, is S6, tab 3, page 755, and that simply shows.
How much greater does the degree of marketing need to be in order to move into the duty of care, where it doesn't exist for a lesser degree of marketing? Is that something that needs to be defined for the purposes of the duty of care?
Well, my lord, the nature of one can rarely have sort of a scientific definition that can be applied in every case. The nature of concepts like proximity and fair, just and reasonable are concepts that are fact specific, and there's a degree of, I mean,
This is true, but if there is difficulty, A, in a definition of who is a problem gambler in the first place, and B, which problem gamblers the duty is owed to, which depends on your case solely on the extent to which there is encouragement, then it might be thought that that rather weighs against it being fair, just and reasonable. To impose a duty in law as opposed to leaving it to the regulation that the Parliament has put in place under the Act.
So my lord, on problem gambler, I say one can fashion a duty that corresponds to problem gamblers without having a finite definition of what a problem gambler is. So you know that if you have a problem gambler, a particular duty is owed. In every case, there may then be a debate as to whether someone is a problem gambler or not. Now within that,
I'm talking about a debate about what the criteria are for defining a problem gambler, which was where we started this morning. And we ultimately got to the position, I think, where you said, well, don't worry about that too much. Certainly, if you know they can't afford it out of discretionary income, they're within the tent.
The way I put it, my lord, is I may have sounded overly flippant there. I didn't mean to. The point I was making is you can judicially legislate for what happens if you have a problem gambler without saying this is a finite list of problem gamblers. For example, my lord, it's like saying we can't. Can you set out rules about stopping the elephant coming in the camp unless you can define exactly what you mean by the elephant? There will be a mainstay of cases where, in my submission, it should be apparent, where it will be very clear that this person has a gambling problem. There will be others where it's less clear. And so, yes, it would be correct that if you fashion the duty, there may be a penumbra of cases where you don't know whether this person is a problem gambler or not. That's open to debate. But my lord, that can exist in other areas of law too. It doesn't provide a reason not to set out a principle for that rump of cases where you've very clearly got a problem gambler. So in my submission, the law should fill that space, even if on the periphery, I accept there may be room for argument as to, well, where does this line end and where does a non-problem gambler start? And so, taking into account the fair, just and reasonable part, my lord, I would submit the civil liability is a fair and reasonable way to ensure the required social responsibility requirements are met. You know, having a regulator is positive, but a regulator doesn't compensate victims of breaches. It'll often allow the operator to retain the funds that it's made, and where it does, it will invariably look at only a clutch of cases. So that's a whole series of people that will not be protected by the regulator financially. And I acknowledge the existence of civil claims potentially, knowing that they might be brought by vulnerable persons to whom duties are owed, would provide an additional impetus to betting exchanges to maintain the required minimum standards. Likewise, an ombudsman. I know friends say, well, the government's talking about creating an ombudsman. Well, again, that's a positive, but it doesn't cover the same territory as private rights of redress. And the existence of one doesn't preclude the other. Now, one of Betfair's arguments is about coextensive duties. Essentially, they say, well, there's no, even if they'd breached their policies, there's no duty because the contract terms are determinative or legally relevant, highly relevant to the scope of any responsibility. They say, well, if there's a tortious duty, it could only be a duty that was coextensive with the contractual duty, and there's no express contractual duty, and the plea in respect of an implied contractual duty failed. So if there's no obligation in contract, ergo there can't be a coextensive tortious duty. I submit that analysis is flawed in two parts. First, the correct analysis of the formation of contracts, and second, the role of the tortious duty. So the argument between both parties was, do you just have one contract at the very start? and then you have various bets placed under it? Or do you effectively have a framework agreement at the start, and every bet under it amounts to a separate contract that incorporates the terms of the framework agreement? And my lords, we argue for the latter of those. The judge found the former, which I submit is a slightly unorthodox way of contractually analysing the position. Yes, a customer signs up to Betfair, signs up to its terms, but those terms don't contain any detail of the however many bets you're going to place. And so those are terms and conditions that will inform any future contractual relations you have. And in much the same way as one has framework agreement and offtake contracts, you have mini contracts formed there under the umbrella of the framework terms, and those terms are incorporated into the, if I may put it that way, mini contracts. And if one analyses it that way, what the judge said is, well, that can't make sense. He took two reasons. One, he said, well, the framework terms say that you have an obligation to keep your contact details up to date. You would need to do that if they're separate contracts. In my submission, that doesn't follow. And he said the main terms have the right to make changes to the terms and conditions, which again you wouldn't need if there are new contracts being formed each time. Again, I submit that doesn't follow. These are framework terms that are incorporated into every contract you enter into. And so if your contact details change, if you want to change the framework terms, you put them in the framework terms. So I submit the more orthodox analysis of the contractual position would have been that you have an agreement at the start, framework terms, and every bet that's placed thereunder is a separate contract. Now, if that's right, I submit it is, then my own friend's tortious duty is off mark, because the duty in this instance would be to exercise reasonable care to avoid harm when a VIP managed problem gambler asks you to facilitate the placing of a bet. So if that duty is complied with, you should not place the bet for them. You should refuse service. That is the consequence of my submission. So in other words, there should be no contract, no mini contract formed. So one's not really in the territory of coextensive contractual and tortious duties. There's a tortious duty, which if properly applied means you don't end up being obliged under the gambling contract that's thereafter formed. My lords,
But if there's a separate contract every time he places a bet, I mean, what happens is where he made a profit. There can't be a breach of a duty of care in those cases.
well, he shouldn't have been allowed to enter into that contract. The fact he does well out of it doesn't change the fact
Well,
that
there's still a breach of the duty of care, isn't it? Is that your case? There's a loss suffered. What's the loss?
well, there'll be no loss, but there's a breach.
Isn't
So if this
the
is
existence of loss an essential prerequisite of the cause of action in tort?
quite so, you would not be able to bring a claim under that contract.
There wasn't a cause of action in that case, was there?
So my lord, I would submit that the way one would look at it would be you will hit a certain point in your knowledge development as a betting exchange where you form the view that this person is likely to be a problem gambler. If you enable, following on from my ground one submission, if you enable the entering into or facilitate bets thereafter, you're in breach of your duty. And if you make a lot of money on one of the bets, no, you've not suffered a loss there. But the point would then be one looks forward from the point, because every instance thereafter involves essentially a further breach. So one would then look at establishing what the net loss is from the point of the first time you became aware. My lords, if you find there to be a duty, I submit that Betfair was in breach of that duty, because proper execution of the duty would have required them to Mr. Gibson to place bets by allowing him to continue suffered loss. They breached the duty and he suffered loss. Now, I come to the next point. If my client makes it this far in the analysis, one were to make it that far in the analysis. The judge took the view that even if there had been a breach of duty, Mr. Gibson would have gone on to lose at least the same sums elsewhere, so he'd suffered no loss. And that approach appears to have been lifted from Mr. Justice Briggs in Calvert and endorsed by the Court of Appeal in Calvert. Now, my lord, I'm conscious of time here, but so
It's perfectly obvious to me you're not going to finish today and you're not going to finish the appeal by lunchtime tomorrow, so I've already set in motion rearranging what I had in the afternoon.
my lord,
So don't feel, you've said now about 5 times you're conscious of time, and I really don't want you to feel you're being squeezed. But on the other hand, we don't, there are some things where we've cut you short, where I think we were quite right to cut you short. I mean, obviously on things like the authorities on the existence of a duty of care, well, we don't really need. And we've cantered over that ground quite a lot in this court. Anyway, so this is the point about he would have bet elsewhere in any event.
yes, this is the judge's point. He would have bet somewhere elsewhere in any event, so no loss, even if duty exists.
Which he did, of course.
Which he did. Now, my lord, I'm going to. There are going to be two parts to my answer to that. So the first is. So my lord, perhaps I'm not sure if you've received. It will probably be up on the screen. The Supreme Court decision in Manchester Building Society and Grant Thornton.
You did send it to us, yes. I think.
So briefly, that case was about expert accountants giving negligent advice on hedge accounting to the building society. And that was then relied on by the building society, which entered into some long-term interest rate swaps to hedge the risk between fixed-rate lifetime mortgages that they issue to their customers and the variable interest rate they'd be borrowing at. There's quite a helpful explanation of the facts by Lord Leggett. Yeah. The accountants it's tab 54 of the authorities bundle.
Yeah.
The accountants later realised they'd made an error, which meant the building society had to restate its accounts, meant closing out the swaps, which meant they had to pay substantial mark-to-market losses. And it tried to claim those from the accountants. Now, so my lord, I'll perhaps show you some of these.
Right.
So if one goes in the judgment to page 790, is that right? Yes, page 790 of the judgment itself. I'm afraid I don't have the.
This is Lord Hodge.
Yes, Lord Hodge, Sales, Reed and Kitchen, Lady Black. So paragraph 4 on page 790 sets out a summary of their views.
Yeah.
And at point 4, which is over the page, a counterfactual analysis was said to be no more than a tool to assess what loss was caused by the breach of duty. So essentially, my lord, this is effectively an interrogation of the Samco line of cases, where one's working out, well, what part of the loss derives from the breach of duty? So what is the scope of the duty? So how much of what followed came from that breach, and how much came from separate matters to which the breach doesn't relate? And their lordships set out their views on this. Page 791, paragraph 6. So they set out a series of questions to be asked when damages are claimed in negligence. And just to get to the point that I just mentioned, page 793, paragraphs 10 to 11, they refer to identifying whether the loss claimed as damages falls within the scope of the duty owed by the defendant. And And then page 794, paragraph 13, they look at the scope of duty owed by professional advisors, which is governed by the reason why the advice is given. And then over the page 795, paragraph 17, they go and refer to Lord Hoffman's mountaineer's knee example, where doctor advises mountaineer his knee's fine, it's not, he goes on a climb, injures himself, but it's got nothing to do with the knee. So it was just making the point in a colourful way. Page 797, paragraph 23, and about part D. This is referring to Lord Hoffman's proposed form of counterfactual analysis. I agree with Lord Burrows that the counterfactual test may be regarded as a useful cross-check in most cases, but shouldn't be regarded as replacing the decision that needs to be made as to the scope of duty of care. And then one goes forward to page 802. Paragraph 38. They set out their views on the scope of the duty, and that involved looking at why the advice was being sought. And that was because from that one can assess the extent to which the eventual losses were caused by the negligent advice and thus by the breach of duty. Now, if one then goes forward to what Lord Legate says, and that's at page 818, this is where his lordship deals with the counterfactual test in Samco Cap. And if one your lordships turn over the page, paragraph 105. There's some discussion about whether the Samco Cap is fair or if it's too kind of ossified as not representing changes in market. But 105, Lord Legate says now's not the time to discuss that. But then the important point for present purposes is more general. So where a counterfactual test is used, it should not be seen as a mechanical exercise. And he goes on to say there are also cases in which a counterfactual test cannot readily be applied. And he gives an example. And at 106, accordingly, it shouldn't be assumed that it's necessary or helpful to apply a counterfactual test in every case. It's simply a means of assessing whether there is a sufficient causal connection between the subject matter of the advice and the loss suffered by the claimant. So, my lords, I pause here and I'm going to query whether a counterfactual analysis would be appropriate at all in the present case. So we're dealing in this part of the case with we're proceeding on the hypothesis that Mr. Gibson makes out the existence of a duty and a breach of duty. But I submit this is the type of case where it's not legitimate to engage in a counterfactual inquiry. I mean, in Calvert, I may be reading the tea leaves here, but Mr. Justice Briggs seems to have been surprised that the relevance of the counterfactual analysis he was positing was not challenged. So that's Calvert, paragraph 198, just for your note. And in that case, it seems Mr. Justice Briggs also took the view that if the wider duty in that case, the duty owed to all problem gamblers, if that were established, he gave permission to appeal on that, it was arguable the resulting causation analysis might have a different outcome. And one sees that in the Court of Appeal decision, paragraph 6. I submit, as Lord Legate stated in Manchester Building Society, a counterfactual analysis is not appropriate for all cases, and this is one of those which is not appropriate. So this case is different from those kinds of cases where a claimant buys an asset or takes on a contractual obligation, interest rate swaps, based on negligent advice. there, the resulting loss in value of the asset or the cost of closing out the swaps may not be caused entirely by the negligent advice. So those are the Samco line. So where the advisor is only providing input on part of what goes into the decision, one can say, well, they're not taking responsibility for everything, for environmental factors like drops in interest rates, or the fact that you had in mind that this was good for your company profile. So there's all these other factors, and you're trying to tease out what part of that loss relates to the negligent advice, and therefore what's the scope of that duty. And so one can see the legitimacy of using a counterfactual as a tool to assess what loss was suffered by the giving of negligent advice. Because one is assessing the extent to which the breach of tortious duty caused a forward loss. A counterfactual testing of those causes in a way that's redolent of contractual damages seems appropriate. But here, my lords, there's no acquisition of an asset. There's no separate contractual obligation giving rise to some forward loss, for which one may need to separate out causative factors towards that loss. Here, there's a breach of duty pursuant to which money is paid over which would not otherwise have been paid over to the defendant but for the breach. If they'd not allowed the contract to happen, the money would not have been paid over. The loss caused by that breach is the money that was paid over to Betfair that would otherwise not have been paid over. I submit there's no meaningful scope for separating out other causative factors that cause that money to be paid over to the defendant.
But that rather assumes that the beginning and the end of the duty question is it's a duty to close the account and prevent any further betting. But the normal analysis when we're looking at duties of care in tort is to analyse whether there is a duty to take reasonable steps to prevent the claimant from suffering a particular type of loss. And the way that the duty would have to be framed in this case is there's a duty to take reasonable steps to avoid Mr. Gibson suffering the losses which he would suffer as a result of his being a problem gambler. Now the exercise of the reasonable care in this case, and what the failure which makes it negligent, is a failure to prevent him continuing to bet with Betfair. But it isn't the question when it comes to causation whether the failure to fulfil the duty to protect him from the consequences of him being a problem gambler would or wouldn't have been avoided by the fulfilment of the duty in this case, i.e. preventing him gambling. And if the position is that closing the account would have meant that his problem gambling led to the same losses elsewhere, then it is a causation question, isn't it, as to whether the breach of duty in this case has caused the loss in the first place. It's not a two-stage test, as it were, of saying it's caused the loss and then at stage two, would it have been avoided for other reasons?
My Lord, I submit that the obligation is on Betfair to use reasonable care to avoid causing harm to Mr. Gibson through their provision of their services. So if they breach that duty.
What type of loss? The answer is loss from problem gambling. That's the kind of loss which we're positing there is a duty on Betfair to take reasonable steps to avoid happening. And that's, as we know, that's question one in any duty of care. What is the type of loss which there's a duty to protect against? So it's losses from problem gambling, isn't it? And then the question is, did putatively Betfair's failure to take those reasonable steps cause the losses from problem gambling?
But my Lord, the Betfair's obligation is not to protect him from problem gambling full stop. Because, for example, if he placed a bet with a rival betting organisation, I would not suggest that that was a breach by Betfair of its obligation. So Betfair is not policing his betting outside betting with Betfair. So when one's looking at, well, what's the scope of the duty, it's that duty inter se between the two protagonists, Mr. Gibson, or whichever customer it is, and Betfair. And so that duty is breached when that bet with Betfair is allowed. It's not breached when the bet with William Hill is allowed, because Betfair can't be expected to police that as part of its duty. So my lord, if that's the case, then the loss that's caused is the loss that's paid to Betfair for breach of that duty. And if one's then looking at it from that point of view, then I submit that counterfactual analysis, which in my submission is aimed at a different type of loss, doesn't appropriately fit here.
But your example isn't a true analogy of what's going on here, because what's said against you is, well, if he hadn't bet with Betfair, if none of these bets had taken place, he would have placed the bets with William Hill. It's not a question of having one bet with Betfair and then another bet with William Hill for which you're not responsible. It's a substitute. So it's saying, it's classic but-for causation, isn't it? I mean, unless you can satisfy us that, there may be issues as to whether he would have suffered the same amount of loss or less loss or whatever. And you may have a perfectly legitimate basis for saying he wouldn't in fact have incurred as much of a loss as he did. But the causation analysis is a but-for causation, unless you can satisfy us that somehow Financial Conduct Authority and Arch applies, which, speaking for myself, I just simply fail to understand. I may be being thick, and I don't particularly like how the Supreme Court's analysis anyway, for all sorts of reasons. Lord Briggs seemed to me to have the right answer. I lost that battle.
So my lord, there's two steps. One, I take the position whether a counterfactual analysis is relevant in the first place. So my alternative
Well, I
bet
follow your point.
was addressing.
You do, but you finish your submission by saying that the counterfactual of a bet with William Hill is a different type of loss.
Yes.
Is it a different type of loss?
Well, it's not.
It's just a different person. It's a loss as a result of problem gambling.
It's the same,
isn't it? It's exactly the same type of loss.
But it's not a loss that arises out of the breach of duty, because your duty as Betfair is not to prevent the problem or not to protect the problem gambler from gambling anywhere. It's to protect them from gambling with you. So if that is the loss, and you're applying a counterfactual, how else would you have suffered that loss?
Are you not confusing what the duty is and how you've breached it in this particular case? I mean, if there is a duty of care, then one imagines that it applies to steps short of excluding people. It may be that there's a failure to take reasonable care, which comprises not giving someone a warning or whatever, which might give rise to loss in a particular case. So that one can't define the duty by reference to a duty to exclude. The duty is to take reasonable care in all the circumstances to protect from suffering a particular type of loss. And unless the counterfactual involves a different type of loss, I'm struggling really to see why it's irrelevant. Anyway, I have your submission on that, but I wanted to articulate it because you can see it's a point that's troubling me.
Yeah.
And if you need to come back to it tomorrow, speaking for myself, of course do.
Yeah.
I will have a think about whether I come back to it tomorrow, my lords. But following the second part of that is if it's legitimate to look at the counterfactual, what is the counterfactual? Now, when one looks at the counterfactual, in my submission, the law has to proceed on the basis that the gambling market would have complied with its LCCP obligations. So at the moment we are in the world where there has been a breach by Betfair of its LCCP obligations. It's caused loss. And in my submission, the law has to proceed on the basis the market would observe their legal obligations. Otherwise, there's no point to any duty because no loss will ever be caused. If one can effectively say, well, this is the Wild West, so yes, we breached our duty, but everybody out there breaches their duty. So tough. That cannot, in my submission, be the correct way to approach it. The unscrupulous gambling operator who's breached his license will never be liable for having done that. And it also means that if you are an unscrupulous gambling operator, you decide to exploit problem gamblers, the chances of them obtaining redress goes down the worse their gambling disorder is. As one says, well, there's a world of people out there that would have exploited you, so you're no better off. So, my lords, I submit that assuming assuming that is correct, and one that has to proceed on the basis that other exchanges would have applied the law, would not have, or at least English law in assessing loss doesn't proceed on the basis that they wouldn't have, then the evidence at trial was they would have quickly noted that he was a problem gambler and refused service. I recognise that means that there would be a bedding in period where he placed bets with them and he would lose some money, and then as they acquired all the relevant information, they hit a point at which they think this person is a likely problem gambler, and they refuse service. And that would be consistent with the evidence at trial from Mr. Brown of Betdac, who is one of the works for a competitor organisation to Betfair. And his evidence was that Mr. Gibson's very high staking of correct score markets would have quickly given rise to concern. If I the reference for that, my lords, is perhaps I should turn it up. S6, tab 13, page 1301. This is for Opus, this is S6, tab 13, page 23. And so, if I just invite your lordships to read from line 5 to the bottom of that page, and then over the page to line 16.
Sorry, can you give me the page number in the...
The hard copy, by the way. The hard copy is page 1301. So this is bundle S6, page 1301.
So the punchline is, if somebody was staking £20,000 on a single correct score market, we would establish our bona fides quite quickly.
Can we go over the page?
What does that mean? We would establish our bona fides quite quickly. We would work out whether he could afford it.
So, my lord, we would work out whether he was, whether he was gambling affordably, sensibly.
I mean, they wouldn't have the history of his losses with anybody else to go on.
No, but
They'd start with a fresh look at what his wealth was and what his overall losses. So £20,000 stake wouldn't necessarily stop him betting with Betfair.
yeah. I mean, the only point I make on this, with Betdac at least, is they did ultimately. So when he did move to after his relationship with Betfair came to an end, when he did start betting with Betdac, they did limit him to £1,000 a month. They placed a deposit limit. So, so my lord, there is in my submission. There's I submit that evidence is consistent with my submission that if one looks at the counterfactual and one takes the view that other betting exchanges will try to comply with their obligations, then they would work out that he's a problem gambler fairly quickly. So
is the counterfactual limited to betting exchanges? I wasn't quite sure why that should be so.
So the reason for that, my lord, is because his gambling addiction was with betting on the correct score markets in football matches, and the only place one can do that is, I understand, betting exchanges.
Lay. Which I don't think that can be right.
I mean, if his pattern was he liked to lay bets, I can see that would require an exchange.
That is correct. It's laying.
You can
bets.
bet on football, on the results of the football match. With anything though, online betting.
It's the laying of bets. Sorry, it's my mistake. I had to be prompted.
Yeah. Okay.
Can I just rise to say something, just in response to my Lord Justice Popplewell's question? My Lord, if your question was, is the judge's finding about what the counterfactual was limited to betting exchanges, the answer to that would be no. What my learned friend has just articulated is what his client's case was.
So you say that the judge has found that Mr. Gibson would have bet on anything in sight, as it were,
That's right.
with a betting exchange or a betting shop or another online betting outfit of some description, not just betting exchanges.
Correct, that's what we said, and that was the judge's finding.
Yeah, that's what I thought.
Yeah.
Thank you.
So, well, my lord, that ends my submissions on why it would be an unsafe conclusion to say that the claimant would have lost the same amount of money elsewhere. That leaves ground 3.
Is that essentially ground 2? Well, that's probably a sensible place to stop then, isn't it, really?
Well, yes.
Okay, 10:30 tomorrow morning, please.
All rise if able.